Hello everyone, welcome back to Legal Roadmap by Nimra Sayani, and today we are going to deal with a very interesting topic, that is oral advocacy and courtroom etiquette in a moot court competition. So let us quickly see what all topics we'll be covering today. So we'll be starting with how to start drafting oral arguments, which is the first step when we talk about arguing. Secondly, structuring your arguments, which is again very important in terms of presentation. Thirdly, how to cite case laws, and we'll also be seeing some of the important courtroom etiquettes. Fourthly, we'll be seeing how to conduct a rebuttal. And lastly, I'll be discussing few tips and tricks which helped me argue confidently even while being nervous. So let me quickly take you through my mooting journey. It helped me win Best Speaker Award and Best Team in an international moot court competition, which was the GD Goenka's Technology Law Moot. Secondly, it helped me win Best Speaker Award and Second Best Team in a national moot court competition, which was the 8th National BP Apte Moot Court competition. Thirdly, it helped me win Best Speaker Award, Best Team Award, and Best Memorial in an intra moot court competition, which was held in our college, which is SVKM Sraveen Gandhi College of Law. And lastly, I also won Best Memo Award in a national moot court competition conducted by Christ University. But today we'll be focusing upon speaking. So let me take you through a fun fact, which might not be very relevant, but I thought to share this because this was something which I felt was a complete circle in my mooting journey. My first ever moot court competition was the same college wherein I won Best Speaker Award and Best Team Award in my final year. And the first moot court competition was in my first year, wherein I went as a researcher because I was not a very confident speaker. And it was also because my friends forced me to take a part in a moot court competition. Prior to this, I was not really keen on mooting, and I did not really think that I can actually moot, let alone win international moot. So yes, that was my journey, and let us quickly start with the video. And we are going to start with the first segment, that is drafting arguments. So, first of all, when we are talking about drafting arguments, we are continuing this video with the assumption that your memorial is ready, because your memo is going to be your primary referral point. So, whenever you're participating in any moot court competition, your first step would be preparing your memorial. I'll come up with a video on how to draft a memorial if you all are interested for the same, and you can tell me about it in the comment section. So, yes, let us start. And the second point would be you have to follow the stream structure as your memorial. So, now when you have drafted a memorial, you have followed one particular structure, right? You have followed your issues with sub issues, and there is a existing structure which is already there in your memo. So, there is no point in deviating with that structure, because most of the times your judge, whoever is judging you, will also have your memo in place while you are arguing. So it is always convenient for the judge if you're following the same structure. Then, another important part is spoken language versus written drafting language. Now, what do I mean by this? So, when I tell you that we are going to follow the memo as our referral point, obviously the memorial will contain written drafting language, which is sort of textbookish, or rather a bookish language, because you are drafting something, right? But when you speak, make sure you change this language to spoken language, because at this point we are arguing before judges who are normal people. We are not reading from the memorial, right? So that is why it is very important to change your written drafting language to spoken language. Then you should also include answers to the questions you can think of. Now, a lot of times you might think that this is a very good argument for a particular side. Now, obviously, in any moot court competition, you are going to prepare from both the sides, the petitioner and the respondent, or the applicant and the defendant, as the case may be. So, over here, you might come across very good points for a particular side. Now make sure you also have a counter to the same from the next side, because chances are, if you have thought about a point which according to you is very nice, chances are the other person or the opponent would have also thought about the same. So now, since you already know the question, it is always better to have an answer beforehand. Then give alternative arguments. Now, obviously, this is optional, but this is something which I have been following and it has helped me immensely. So, a term which I would like to introduce here is arguendo, which basically means assuming but not admitting. This is something which, in my first year, some seniors had, talked about this, and they had helped me understand the importance of the same. And since then, I have been following it too. So basically, what it means is that you are saying that I am right, but even if I am to consider your stance, even then I am right in fancy terms. So, to give you an example, it basically tells us that first of all, I'm going to give you my line of argument, that is my stance on a particular issue. But even if I am to consider your stance, even if I am to consider your argument, that is your opponent's argument, even in that case, I am right. So that is your alternative argument. For example, we had this issue in a moot court competition wherein the question was whether or not are you liable for certain penalties for not following a prime minister's order. So our first stance was that these were mere requests and not orders by the prime minister. And why? Because the term request was reflecting in a moot court proposition. So that was our first stance. And then we said arguendo, which is basically you're saying assuming, not admitting. Even if I am to assume that these were orders and not requests, I could not give the particular data because I did not have that data in my with me in the first place. So that is basically a factual argument. So I gave a legal argument first, and then I considered the argument of the opposite side and gave a factual argument, which is an alternative argument. So that brings a very good structure to your argument. Lastly, you should always ask the judges if they're satisfied or if they have any questions in relation to any issue which you are speaking. So, what this does is it helps you in the way that if you are asking this question after you have finished a particular issue, and if the judge brings up a question relating to that issue, you will be able to answer it in a better manner because you have freshly argued that issue, as opposed to a situation wherein you have argued two, three issues and then you are going back to a issue which was argued earlier. So that was about drafting arguments. And now let us quickly see what you should remember while structuring your arguments. So, first and foremost, introduce your side and stance in the beginning itself. So, what do I mean by introduce your side? You have to mention whether you are appearing on behalf of the petitioner or the respondent, and along with this, also mention your stance. It is not enough to simply mention whether you are the petitioner or the respondent. You have to mention your stance as to what you are arguing or what you are asking for the as a remedy in the court in the present matter. So if I am the respondent, I would be saying, so the council is appearing on behalf of the respondent, which is the government of India, and the council believes so and so. So whatever your stance is for that particular matter, then be clear with your prayers, that is the remedy you are asking. And you, the reason why your prayers is very important, whether it is your memorial or your argument, is because that is exactly what you're asking before the court, right? So if you're not asking a correct prayer, then no matter how good your arguments are, your final conclusion falls flat. Then this is one funda which I have been following in all my speaking competitions, whether it is a debate or it is a moot court competition. And this is something which our English faculty had, mentioned once while we were preparing for a debate. And since then, I have been incorporating the same in all my oral arguments. So the funda is summarize, speak, summarize. What it means is, first you tell them what you're going to speak, then you tell them what you are, basically your entire matter, that is the main content, and then lastly tell them what you have spoken. So you are once again summarizing what you've spoken. So this basically makes sure that the other person, which is the judge or the opponent, know what you have spoken and they remember the same in a very structured format. Further, you can always divide or club issues according to the subject matter. So, in some moot court competitions, you might have to form your issues, and in most of them, the issues are already formulated. So, if you think that maybe these two issues are going together and it is not given in the same format in your moot court proposition, you can always change the same and always follow the moot court rules according to a particular competition. But in general, if you feel that you have to divide a particular issue or you want to club an issue, you can always do that. But always remember, the same should also be done in your memorial, because if you are following something in a memo, you should always keep the same structure in your oral arguments as well. Then make sub issues to give a flow to your arguments. Now, this is something which is very important even in your memo as well as your oral arguments, because when you have sub issues, you have clarity about your main issue, first of all, and secondly, it is easier for the other person to understand as it gives a flow to your arguments. Then always correlate with the facts of your case. This is the last and very important points in terms of structuring arguments, because I have seen a lot of people having very good arguments along with really good case laws, but they are not correlating that with the facts of the present case. So obviously, because you are in before a bench for your moot court for a particular case, if you're not relating that to all the arguments which you might have, then it does not really make sense, right? So it is always better to correlate with the facts of your own case. Then let us see the third important segment, that is citing case laws. Now, when I say citing case laws, I am referring to the case laws which you will be using in your oral argument. So, in a memorial, obviously, you will try to put as many case laws as you can, but while speaking, you have to filter that out to the most relevant cases, because you do not have a lot of time to speak, and whatever you speak has to be on point. So, it is very important that you pick and choose the most relevant cases. Then you should know the subject matter and the relevance of the case you are citing. So it should not be the case that you just cite a case and you do not know anything about it. For example, if I am to cite KS Puttaswamy versus the Union of India, I should know that the subject matter of this case revolves around right to privacy. And I should also know how this case is relevant to the case which I am arguing. So these are few questions which the judge might also ask you. So it is always better to have these details beforehand. Then you can also point out the page number and paragraph number from your memo. This is something obviously which is optional, but I feel this is very convenient. And at the end of it, make sure whatever you're doing, you make it convenient for the other person who is listening to you. It is basically you have to make it convenient for them to understand your arguments, because you are going to speak a lot of things, and if it is a good structure which you are following, it is always easy to understand. So you can basically say that if I may draw your bench attention on page number so and paragraph so and so from my memorial, that will bring them to the page number and paragraph number where your case law has been cited. Now, a lot of times there might be a lot of information in a case law which you have mentioned in the memorial, but due to time constraint, you might not be able to speak all of it in the oral argument. So you are going to pick some important aspect from it and speak regarding that from a particular case law. But when you bring the judges on the same page, they will also be able to view all the other additional details in relation to that particular case law. Now let us see some courtroom etiquettes. I have put the PDF of this particular courtroom etiquettes document in the description box, and you can access the same. And this is what it looks like. So these are few courtroom etiquettes which I have just mentioned roughly. This is something which you can just refer last minute to polish on your oral arguments. So when we talk about judges, we do not refer to them as judge in a moot court competition. We either refer to them the bench, or traditionally terms like your lordship and ladyship were also used, but I personally prefer the bench. So, for example, you would be saying that there are two issues before the bench today. So, you're referring to them as the bench. Then instead of saying thank you should say much obliged, which is a legal jargon. It For an example, you can take this as, if somebody has asked you a question, if a judge has asked you a question, you can always say much obliged for the question, which translates to thank you for the question. This also gives you time to mentally comprehend the question rather than just directly answering it in a panic. Then ask permissions where required. This basically shows your courtroom etiquette, which might not be something which is followed in a real courtroom, but since we are talking about moot court competitions, these are few things which might score you some points. For example, may I, or you can refer yourself as the counsel, and you can say, may the counsel proceed with the first issue at hand. The person or the judge is going to say yes, and then you will answer with much obliged and begin with your issue. Then fourthly, end with prayer, which is very important. I have time and again talked about the importance of prayer. And the reason why this is important is, even though you might have excellent arguments, if your prayer is not on point, then your remedy is not something which you'll be getting, right? So whoever is dealing with the last issue has to expressly read out the prayers from the memorial. However, even the speakers which have spoken initially, they will also be conveying the prayer in relation to a particular issue while they are, dealing with that issue. Example, thus the respondents pray for the dismissal of the present petition. Now, this might be one of the prayers. So, this prayer would be spoken by a person who is dealing with the maintainability of the petition. And lastly, जब सारे prayers हो जाएंगे, whenever your arguments are complete and all your prayers are spoken, the last speaker has to mention that expressly. Then one another point which is left is that you can refer to the moot proposition as the factual matrix of the case, or the fact sheet, or even the moot proposition. Factual matrix of the case sounds a little more fancy. Then introduce a side in the beginning. We've already talked about this. Then another point which will help you with managing your time is, if you're the first speaker, you can ask the judge if they are well versed with the facts. If they say no, then you should be able to speak the facts briefly. But a lot of times what happens is that you might be in a round wherein already few people have argued before you, so the judges might already know the facts. So asking them this question saves you some time in case they tell you that they are already well versed with the fact. The example would be, if the bench is aware about the facts of the case, the counsel seeks permission to proceed with the issues at hand. Then it is always preferable to have sub issues. You can divide the issue as per your research and deal with the aspects individually. If you don't know something, now this is very important. You should not be very say something and then not follow through. So if you say you will get back to the bench, you should get back to the bench, and you should only say this if you can find the answer with the material available with you, or you feel that your teammate would be knowing the answer and you would be able to discuss and get back to the bench. If you can't find it, if you know that you will not be able to find a particular answer, it is always better to admit that you're not aware about it. So it's always better to be true to yourself. Then if you're citing any case, have the citation handy. If you are citing a particular case, you should have the citation which the judge can refer to look up that case. Then know which court ruled in the said case. So you should know whether this is a judgment by the Supreme Court or the High Court, or it is an older judgment by a Privy Council, for etc. And you should also know the brief facts of the case. So if I ask you what happened in this case and how is it relevant to your case, you should be able to answer that in a line or two. Lastly, you can carry your barracks, your commentary, and your oral arguments document for your reference during your moot court competition. So, in case there is a question which you have not prepared, you can always look that up as a team and then get back to the judges. Let us move on to rebuttal. Now, the first and foremost, you have to keep it very crisp and to the point. Rebuttal means you are basically responding, you're replying to something, and that is a thing which is followed throughout the competition. First, the petitioner speaks, and the respondent is basically responding to the first line of arguments. Now, whatever the respondent has spoken, the petitioner is going to respond to that in the rebuttal. And sur-rebuttal is basically the response of the rebuttal of the petitioner, which will be done by the respondent. So at this point, do not add new contentions, because rebuttal itself means that you are responding to something. So if you are responding to something, obviously there are going to be no new contentions at this juncture. Then refute the opponent's arguments. If you are not able to follow the structure, always remember whenever you're speaking, you have to respond to the person who has spoken before you from the opposite team. So no matter what stage it is, whether you are the respondent speaking for the first time, or whether it is a rebuttal or a sur-rebuttal, and always rebut gracefully. Do not, sometimes you might feel that you have had a very good round and it is very evident that you have spoken in a better way than the opponent team, which you might be right or wrong, that is a different story. But do not take that to your ego and start being sarcastic or disrespectful to the other team. That is a very wrong practice to follow in any competition, let alone moot court competition. So always make sure that you are doing this gracefully. Then add only the most relevant case laws, and that is very very subjective, depends on the rebuttal or the arguments which have been made before you are speaking. So you should not cite case laws which are not relevant. Cite only the case laws which are relevant to back your arguments in a rebuttal. So if you are saying something, or if you're responding to something and you want to add some sort of validity to it, you can cite a case law. Or if there is a point of difference in what the other person has spoken and what you are speaking, at that time you can use a case law to point out the difference. Then choose the speaker depending on the issue which needs to be refuted. That is, if it is allowed as per your moot court competition. Now, the reason I am saying this is sometimes, even in a team, you might feel there is a speaker who is better than the other speaker. This is something which is there in your head internally, and you might just allocate the speaker in the beginning. And sometimes what might happen is that the issue which you need to refute is from the contention of the other speaker. So that is why you should not allocate a speaker beforehand. And this is something which we had done in the final rounds of the GD Goenka's International Moot Court competition, wherein we said that okay, this is the time allocated for the rebuttal. However, we will allocate the speaker depending on the issues, and that is something obviously which we'll know once the arguments have ended, right? So that was one thing about the rebuttal. Now, let us quickly see some tips and tricks which helped me. You can incorporate your courtroom etiquettes in your oral arguments draft. Now, this is something which I had done is because I was somebody, and I am somebody who speaks very fast. So it is very easy for me to, miss out on certain things, or it is very easy for the other person to miss out on things which I'm speaking because I'm speaking so fast. So that is why there might be a situation wherein I might forget to follow a particular courtroom etiquette because I'm speaking that fast. That is why I always incorporate all my courtroom etiquettes, which are very basic. For example, greetings to the bench. I include that in my oral arguments document itself. Then, if you have some sort of permission which you have asked, I include that in my document, and I also add dash much obliged. So that makes me follow the courtroom etiquette, and it also gives me some time to comprehend what the other person has spoken. So even if I'm nervous, I'm able to at least understand the question before answering. Then have a summary ready in case there's no time. This is something which is very important. You should be able to know your issues so well that you are able to summarize it to somebody in case you have no time. So it might be the case that your normal speaking time is 15 minutes per issue, but because of something which has happened, or because your other speaker has taken so much time, or the judge does not have as much time, or you have spent a lot of time in a particular issue and now you have very less time, the judge might tell you that okay, summarize your arguments. So at that point, you should not be nervous. You should be able to speak very confidently and briefly. Then you should also be well versed with the facts of your case and your teammates issues, because a lot of time you might divide the issues and then don't look back to what the other person is doing. That is not a right practice. You should always know what your issues are in its entirety. So there might be a case a judge has asked you a question which is not in lines of your issues, but it is something which your teammate is dealing. So at that particular point, rather than saying that you do not know about this and your counsel is going to talk about it, it is always better to answer briefly, maybe in a line or two, and then follow it by saying that my co-counsel will be dealing with this more brief, or more elaborately in their contentions. Then this is very subjective. no rebuttal is better than a bad rebuttal. Sometimes you have had good arguments and then you might not have anything to speak in a rebuttal, and then just going and speaking something for the sake of it might backfire. And obviously this is very rare. A lot of times you will always have something or the other to speak, because there is a person who has spoken before you from the opposite team and you are going to respond to that. So at that particular time, obviously you will be going for the rebuttal. So that was few of the tips and tricks which helped me. And lastly, I would like to tell you, do not forget to enjoy the process and make some beautiful memories while you are mooting. Some of my closest friends that I have still date are people I have, gotten close to while mooting. So don't make it like a very tedious activity and don't enjoy. So obviously it is something which is going to be a part of your law school journey, but make sure you also enjoy the process while you are at it. If you have any questions which you want me to answer, you can leave that in the comment section and I will try to respond to the same. Thank you so much and all the best for all your moot court competitions.